Could Article 4 ruin your HMO? Be careful. Even if you've got the property license, Article 4 direction may still stop you in your tracks. In some London boroughs, well, most, renting to sharers without the right planning consent can lead to enforcement notices, fines, or even being forced to evict your own tenants. So stay tuned, because we will explain exactly where Article 4 is, what is it, and how to stay compliant if you're planning or already managing a HMO.
We're Abs and Adam. Welcome back to our channel, where we help landlords stay compliant, avoid costly mistakes, and help maximize their rental performance. So let's break it down. What Article 4 really means for landlords. Well, what is Article 4? First thing to make abundantly clear is Article 4 relates to the planning department of a council, not the license department. They are totally different, isolated entities. So in terms of planning, under permitted development rights, you can use a property from a single family home, what's used class as C3, as a small HMO for up to 6 people, 6 individuals, used class C4, without needing planning permission. Because of permitted development rights, most landlords have simply operated HMOs without acknowledging the use class. So when the local council introduces Article 4 direction, it removes that automatic right. That means if you want to rent to sharers, even just 3 or 4 people, you'll need to now apply for full planning permission before you can do so, regardless if you already have a valid property license in place, whether it be additional or mandatory.
So why councils use Article 4? Councils can use Article 4 direction to control the spread of HMOs in certain areas. They claim it helps protect the balance of local communities, prevent overcrowding, and reduce antisocial behavior.
Yeah, it does.
Yeah, it does. In essence, they want to avoid high density of transient sharers, which reduces the amount of families in that area and also puts a strain on the local resources. So family-rich areas are more likely to be safer and have a more stable community feel. In practice, though, it means landlords in those areas face stricter planning controls, and many don't realize until it's too late. So where does Article 4 apply in London? Well, Article 4 directions are in place across many boroughs, probably most. Some most notable examples, you got Brent, Enfield, Haringey, Lewisham, Islington, Waltham Forest, Ealing, Hounslow, pretty much nearly all, right? Newham. Newham being the kind of the first ones to the punch, really, and probably the most strictest on that. Each borough defines its own boundaries, so sometimes it can be by the street or by the ward or borough-wide. So always check your council's Article 4 map before converting or using a normal house for sharers, just to make sure you're using it correctly. If you operate a HMO without planning permission in an Article 4 area, the consequences can be serious. The council can issue an enforcement notice requiring you to stop using the property as a HMO. If you ignore it, you can face substantial fines, legal action, and be unable to legally rent the property to multiple tenants in the future. It can also make it harder to sell or remortgage, since lenders often ask to see evidence of the planning consent for HMOs.
So how do you stay compliant? Well, what can you do? Well, check Article 4 coverage early. Before buying or converting, search your council's website to confirm if Article 4 applies where you are. You can also get planning advice, speak with a local planning consultant, architect before submitting your HMO license or making any layout changes. Apply for planning consent if you're within a restricted zone, include fire safety layout, amenity details, anything you can to strengthen your case. Also, you can keep evidence of when your HMO use began. So if it was established before Article 4 took effect, you may be able to apply for a certificate of lawful use instead of doing a full planning permission. So if you've been using it for a long time as a HMO, please keep the records as much as you can.
It will help. To recap, licensing and planning are separate. So one common mistake is that landlords thinking that they're the same. A property license is planning permission. It's not. Licensing is about safety and management, whereas planning is about the land usage, completely separate. You can have a valid HMO license, but still be in breach of planning law in Article 4, and you didn't get the consent from the planning department. So you need consent from both in Article 4 areas.
Let's check both.
If you found this useful, don't forget to like or subscribe to help stay informed and protected.
See you in the next video.